Welcome to the Bar Exam Toolbox podcast. Today we are walking through a California trust question. This is another in our series of podcasts talking about how to approach questions on the California bar exam. Your Bar Exam Toolbox hosts are Allison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Allison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are walking through a trust question. This is another in our series of podcasts talking about how to approach questions on the California bar exam. And don't forget to subscribe to our podcast so you won't miss any upcoming essay discussions. This question works through three areas of the law: wills, trusts, and property. Though each area is connected to the others, it will be important to work through different legal analyses depending on which part of the question you are answering. Before we talk about today's question, we need to do a quick review of the law that you will want to know for this question. Now, question 1 asks you to analyze the interests different parties have in real property following a trust and then a will. So here are some of the basics of trusts. A valid trust is created when a settlor, the entity that establishes the trust, has the intent to give the property to a beneficiary. An inter vivos trust is created during the life of the grantor. A private express trust is created for the benefit of one or more ascertainable beneficiaries. For a trust to be valid, there must be a grantor, intent to create a trust, ascertainable beneficiaries, a trustee, property, and a valid trust purpose. A settlor can revoke a trust if he or she is alive and has reserved the right to revoke the trust. It can also be terminated if the material purpose of the trust has been fulfilled. A trustee holds legal title of the property. A trust will not fail for lack of a trustee. A court will appoint a trustee. A testamentary trust is established in the grantor's will. An executory interest is a future interest that will divest a prior interest when a specific event occurs, and a shifting executory interest will divest a prior grantee. A present possessory interest occurs when there is a current interest in the property. The interest is subject to an executory interest if it can be divested by a third party upon the occurrence of a specific event. Now, question 2 asks you to analyze the duties of a trustee and the remedies a beneficiary may have if a trustee violates these duties. Here is a summary of those duties. A trustee must hold the trust for the benefit of the beneficiaries. Trustees have the duties of loyalty and care, and they must act as a reasonably prudent person would. The duty of loyalty requires a trustee to prioritize the interests of the trust. When a trustee engages in self-dealing, the duty of loyalty is breached. Self-dealing occurs when a trustee uses the trust assets for his or her own benefit. Even if the self-dealing is beneficial for the trust, this is a violation of the duty of loyalty. The duty of care requires a trustee to act in good faith on behalf of the trust. The duties of impartiality and prudence fall under the duty of care. The duty of impartiality requires the trustee to balance the interests of the remaindermen and the principal equally. The duty of prudence requires the trustee to behave as a reasonably prudent person would under similar circumstances. If the trustee has special skills, he or she is held to the standards of the skilled person. Remedies for breaching these duties vary based on the breach. Beneficiaries can seek to have trustees removed when they breach their duties, and beneficiaries can seek to recover funds via tracing when self-dealing is involved. Okay, so now that we've got the law, let's move on to reading the bar exam question. This is a question from the February 2016 bar exam. We will link to a webpage where you can find this question in the show notes. Wendy, a widow, owned a house in the city and a ranch in the country. She created a valid inter vivos trust, naming herself and her daughter, Dot, as co-trustees, and providing that she had the power to revoke or amend the trust at any time in writing, by a document signed by her and delivered to her and Dot as co-trustees. At Wendy's death, Dot became the sole trustee and was directed to hold the assets in trust for the benefit of Wendy's sister, Sis, until Sis's death. At Sis's death, the trust was to terminate and all assets to be distributed to Dot. The sole asset in the trust was Wendy's ranch. Years later, Wendy prepared a valid will in which she stated, "I hereby revoke the trust I had previously established and leave my house and my ranch to my son Sam as trustee, to be held in trust for the benefit of my brother, Rob. 5 years after my death, the trust shall terminate and all assets then remaining in the trust shall be distributed outright to Sam." Then Wendy died. Following her death, both Dot and Sam were surprised to find her will. Dot has refused to serve as trustee under the Inter Vivos Trust and claims that, as a result, the trust fails and that the ranch should immediately be given to her. Sam has agreed to serve as trustee under the Testamentary Trust and claims that the ranch is part of the trust. Sam then sells the house at fair market price to himself in his individual capacity and invests all the assets of the trust in his new business, Sam's Solar. Bob objects to the sale of the house and to Sam's investment. Number 1. What interests, if any, do Dot, Sam, and or Bob have in the house and the ranch? Discuss. Number 2. What duties, if any, has Sam violated as trustee of the Testamentary Trust, and what remedies, if any, does Bob have against him? Discuss. Now, the first thing you should do is mark up your exam paper to assess what is legally significant about each fact in the fact pattern. The order of the facts is important in this question, so it makes sense to list them chronologically. So first, Wendy is a widow. In community property states, like California, there are specific rules about spouses and inheritance, but because Wendy is a widow, we can dispose of those issues. Wendy created a valid Inter Vivos Trust. We know the trust is valid, so there will be no need to spend time determining its validity. Wendy named herself and her daughter Dot as co-trustees and provided that she had the right to revoke the trust at any time so long as she did it in writing in a document delivered to herself and Dot. Then some trust details. Upon Wendy's death, Dot would be the sole trustee. Dot would be directed to hold the assets of the trust for the benefit of Wendy's sister, Sis, until Sis's death. So we will need to analyze what kind of estate Sis holds. Then when Sis dies, the trust will terminate and the assets go to Dot. And the only asset in the trust is the ranch. Then we know years after the trust was formed, Wendy then executed a valid will. So the fact pattern says that the will is valid, so there is no need to work through that as an issue. We know we will need to analyze whether a new will trumps an older trust. Now in the will, Wendy revokes the previous trust. We will need to analyze what steps must be taken to revoke a trust. Is the will enough? Wendy then leaves the ranch and the house to her son Sam as a trustee for the benefit of her brother Bob. So Sam and Bob have different interests in the properties. We will need to analyze those. The trust is supposed to last 5 years after Wendy's death, and then the assets will be distributed outright to Sam. Then Wendy dies. Dot and Sam were surprised to find her will. Remember that Wendy wrote into the trust that it could only be revoked in writing if delivered to herself and to Dot. Dot refuses to serve as a trustee under the trust. So this means that there are no remaining trustees. Now Dot believes that because there are no trustees, the trust fails, so the ranch should fall directly to her. We will need to review what happens when a trustee is unwilling to serve. Sam is willing to serve as a trustee for the Testamentary Trust. So this comes with a set of duties. Sam believes that the ranch is part of the Testamentary Trust. There is now a conflict between the Inter Vivos Trust and the Testamentary Trust. Sam sells the house to himself at a fair market price and invests the proceeds into his own business. This is a flag to discuss the duty of loyalty. And lastly, Bob objects to Sam's sale of the house and subsequent investment. This is a good place to start thinking about remedies that beneficiaries can seek. So now let's look at how you actually answer this question. You would want to start any outline or answer by breaking your paper into 2 parts. to answer both questions asked. The first part should be broken into 3 sections to assess each of the parties' interests in the house and the ranch. And the second part will address Sam's duties and violations as well as remedies. You can address the remedies in their own section, or you can include a brief discussion in each duty section. Number 1, what interests, if any, do Dot, Sam, and or Bob have in the house and the ranch? Discuss. And number 2, what duties, if any, has Sam violated as trustee of the testamentary trust, and what remedies, if any, does Bob have against him? Discuss. You are asked to answer 2 very different questions. As you draft your answer, make sure you address each one fully and separately. Preparing an outline as you mark down issues is an effective way to make sure you do this. So let's look at each question separately. First, let's take each person individually to see what interests they may or may not have in the house and the ranch. So first, let's look at Dot. Our rule here is that trusts are presumed to be irrevocable unless otherwise stated. Now, our analysis is that Wendy and Dot were the trustees of the trust, and the ascertainable beneficiary is Wendy's sister, Sis. Wendy intended the trust to be revocable, so long as it was done in writing and delivered to both trustees. Thus, this trust was valid, because the fact pattern made this clear, and revocable. Now, Wendy's subsequent will explicitly revoked the trust. This satisfies the writing requirement laid out in the trust. The issue here is whether the will was delivered to Dot, however. Because Dot was surprised when she and her brother found the will, it is clear that the writing was not delivered to her. Because the trust revocation was not delivered to Dot, the trust was improperly revoked, and so the trust is still valid. So the ranch remains trust property. The next rule here is that a trust will not fail for lack of a trustee. The court will appoint a new trustee. So here our analysis says that Dot is refusing to be a trustee for the inter vivos trust, believing that if there is no trustee, the trust will fail and the trust property will fall to her immediately. Now, the court will appoint a trustee, so this trust has not failed. The trust provides that Sis is the beneficiary until her death, and then the assets will be distributed to Dot. Sis has a life estate, and Dot has a remainder interest. Dot's interest in the ranch will vest upon Sis's death, so she has a vested remainder interest in the ranch with no present possessory interest. Now let's turn to Sam. The fact pattern tells us that the will is valid, so there is no need to spend time analyzing that issue. Our next rule that we need to deal with is that a testamentary trust is created by language in the will, and property goes to the trust instead of probate distribution. Our analysis here is that Wendy created a testamentary trust when she wrote that the house and the ranch were to go to Sam as trustee for the benefit of Bob. Our next rule is that the trust must specify which property is to be included. Here, Wendy intended to include the ranch and the house in the trust. However, because her inter vivos trust was not properly revoked, the testamentary trust will only include the house. Our next rule we need to look at is that an executory interest is a future interest that will divest a prior interest when a specific event occurs, and a shifting executory interest will divest a prior grantee. So our analysis here is that Sam's interest will divest Bob's interest 5 years after Wendy's death. Thus, Sam has a future interest in the house. And Bob. Our rule here is that a present possessory interest occurs when there is a current interest in the property. The interest is subject to an executory interest if it can be divested by a third party upon the occurrence of a specific event. Now, our analysis here is that Wendy established the trust for the benefit of Bob. Because Bob is not the trustee, he will not hold legal title. Bob has a present possessory interest in the property, but because Sam has a future interest in the property, Bob's interest is subject to an executory interest. The house should be held in trust for Bob for 5 years, and then it should go to Sam. Here's a quick breakdown of the final disposition. The ranch goes to Dot as trustee for the benefit of Sis for the duration of Sis's life. Because Dot declined to be the trustee, the court will have to appoint a new one. When Sis dies, the ranch will go to Dot, who has a remainder interest, and Dot has a future interest in the ranch. The house is supposed to go to Sam for the benefit of Bob for 5 years. After 5 years, the house goes to Sam outright. Bob has a present interest and Sam has a future interest. Whew, we did it. Now let's review question number 2. Trustees have the duty of loyalty and care, and they must act as a reasonably prudent person would. Our rule here is that the duty of loyalty requires a trustee to prioritize the interests of the trust. When a trustee engages in self-dealing, the duty of loyalty is breached. Self-dealing occurs when a trustee uses the trust assets for his or her own benefit. Even if the self-dealing is beneficial for the trust, it is a violation of the duty of loyalty. Here, our analysis is that Sam engaged in self-dealing when he sold the house to himself and invested the proceeds into his own business. Even though he paid a fair price for the house, he has breached this duty because the trust does not explicitly provide for self-dealing. We have another rule about the duty of care. The duty of care requires a trustee to act in good faith on behalf of the trust. The duties of impartiality and prudence fall under the duty of care. Here, our analysis is that because Sam invested all of the money into one business, his business, he violated the duty of care. It is not reasonable for a trustee to risk the funds in this way. Our next rule is that the duty of impartiality requires the trustee to balance the interests of the remainderman and the principal equally. Now, it's pretty clear in our analysis that Sam was not impartial here. He used the money from the sale of the house to invest in his own business. Sam is the remainderman, but he still has a duty to be impartial in his investments, even if the investment would benefit Bob. As it is, nothing remains in the trust for Bob. Our next rule is the duty of prudence requires the trustee to behave as a reasonably prudent person would under similar circumstances. If the trustee has special skills, he or she is held to the standard of that skilled person. Our analysis here is that Sam sold the entire property of the trust and invested it in one business, which is not prudent. A reasonably prudent person would have acted with caution. All right, our last rule is that remedies for breaching these duties vary based on the breach. Beneficiaries can seek to have trustees removed when they breach their duties. Beneficiaries can seek to recover funds via tracing when self-dealing is involved. Our analysis here is that Sam breached several duties. Bob can ask the court to have Sam removed as trustee, and the court will likely grant this. Additionally, Bob can seek monetary damages from Sam. Tracing the money and profit from the sale of the house will allow the court to determine the value of the damages. So now, that's it. Can you believe it? We made it through that pretty difficult trust question. Now, when there are two distinct questions, it's important to allot enough time to outline both of them before you begin writing. If you prepare for the bar by practicing your rule statements, drafting these outlines will be a simple process on test day. Make sure you create solid attack plans so that you can memorize the rules, as this will give you the confidence you need to succeed under the time pressure of the exam. And with that, we are out of time. I want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California bar exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you are still in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to myself or Allison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.